Stephen Wainwright and Richard Wainwright.
Ms. Rabe?
May it please the Court, my name is Jane Robbie. I'm the Assistant Bar Counsel representing the Bar Council in the matter against Stephen Wainwright and Richard Wainwright. The issue today is whether the Board's recommendation of a 3-month suspension contingent upon the taking and passing of the MPRE exam is appropriate discipline in the circumstances where 2 lawyers working in the same law firm undertook to represent 2 clients, one, Mr. Baggia, a long-standing client of Stevens, a developer and the debtor, and 2, Mr. Boyer, an excavator, who was owed $52,500 for excavation services, but in this transaction was looking to address the $45,000 of that debt. By representing these 2 parties in a real estate transaction, the purpose of which was to enable Mr. Baggia to repay Mr. Boyer the money that was owed without obtaining the client's consent, informed consent to the conflict, and causing substantial injury to Mr. Boyer, the creditor, while giving substantial gain to Mr. Baggia, the long-standing client of Stevens and the firms. And other unique circumstances are involved here as well, because Stephen Wainwright not only had a long-standing attorney-client relationship with Mr. Baggia as a developer, he also had a business relationship with Mr. Baggia and was himself a creditor to Mr. Baggia. And at the time of this transaction, Mr. Baggia owed over $500,000, had defaulted on that. Some of it was for legal fees, and some of it was loans that were extended by a trust, the Honey Realty Trust, that Stephen had developed, had created for his wife and his mother-in-law, and they had loaned $450,000 to Mr. Baggia, and he defaulted on those. So under these circumstances, Stephen and Richard were in a unique position to know the risks to Mr. Boyer in going into a transaction with Mr. Baggia.
Can I ask this question, and it's a procedural one, but the loan that we're talking about here, the principal loan, this $250,000 loan, which had several moving parts, which was an effort to sort of reconcile some of these debts, and is that correct? That was in 1990?
That's correct. That was a construction loan. The purpose was to rectify the debts.
Correct.
But it was guaranteed personally by Mr. Boyer.
And his line of credit, I understand.
That's correct.
I understand. But that loan was completed, or at least was, the deal was, papers were signed in October of 1990?
That's correct. And then after that...
Thinking back on that was 4 careers ago for me, so I'm just looking back at a long time here. And by 1993, in fact, all of the facts that we're talking about now were known. All of the losses had been suffered. The condos had been sold, which were the vehicle by which all of these loans were going to be paid off. So all of the damage had been done. That, again, is 14 years ago, 13
That's
years
correct.
ago. A complaint is filed some 3 years after that. What prompted that? What happened in those 3 years after all of the facts were known that sort of caused a complaint? Do you know?
Mr. Boyer didn't always know about the Office of the Bar Council or the Board of Bar Overseers. When he learned about that, he filed his complaint. And he learned about that while he was trying to get a lawyer to represent him to file suit against the Wainwrights. And one of the lawyers he consulted with told him, I can't take this case, but you can file a complaint with the Board of Bar Overseers, the Bar Council's office. That's my understanding.
So he got that advice sometime around 3 years after the...
That's correct. when he was searching for counsel.
Then the complaint gets filed, the petition for discipline gets filed almost exactly 5 years after that?
That's correct.
What happens in that 5-year period, just out of curiosity?
Well, as you know, there were a lot of backlogs in cases at that time, but in addition to that, sir, there were other problems and reasons for the delay. Bar counsel was trying to get from Richard Wainwright his original file, did not receive his original file until much later. Now, bar counsel charged that he failed to cooperate for this reason, but that was not found.
Okay.
But you're asking about reasons for delay. Getting the information was difficult, and also there were other issues that came up. Bar counsel did want to have an opportunity to have a respondent meeting with Stephen Wainwright. At a certain point, his illness interfered with that. I'm not saying that's the entire cause of the delay, but if you're asking about it, and I would also point out that the majority of the delay occurred after the petition for discipline was filed. I mean, it took another
5 years.
Pardon me?
Another 6 years after.
It took 6 years. And for that, I would also indicate, to Your Honor, that the respondents, Richard Wainwright, just 1 week before the hearing was supposed to start in September of '02, asked for continuance and received it, and to get counsel, and he did get counsel, and then the hearing was held.
Honestly, I'm not trying to assess blame here. I'm just looking back and saying, how is the public protected? What kinds of perceptions have we now created? We're fighting about whether these individuals should be publicly reprimanded for something that occurred, in essence, in 1990, or whether maybe they should be forced to take the MPRE on threat that they will be suspended for a short period of time if they don't, or maybe they'll be suspended and not let back in for a short period of time and not let back in if they take the MPRE.
Well,
Isn't this kind of sad?
I would suggest that the taking of the MPRE, that recommendation for discipline was prompted by conduct that's quite recent, and that the hearing committee, and the appeal panel of the board felt that the respondents did not recognize the disciplinary violations that were involved and incorporated that as part of their recommendation for discipline. That doesn't go back to 1990. That goes back to last year.
But it's part of the sanction, and part of it's part of what's being recommended here.
Yes, and I would also say in matter of gross, the court said that the passage of time is not an appropriate factor in mitigation because many violations otherwise would go unvindicated.
I'm almost not even talking about mitigation here. I'm just talking about 17 years. One of these gentlemen was 58 when the transaction closed. He's 75 now. I mean, think about that.
I understand that. In this case, the conflict of interest was obvious and the violation was blatant. Two clients, debtor and creditor, had differing and conflicting interests. Richard structured the deal. Stephen executed the deal. Neither Stephen nor Richard advised Boyer or Bagia of their differing interests. Neither of them advised Mr. Boyer, for example, to go and speak to independent counsel of the transaction before he signed a personal guarantee on a $250,000 construction loan to Mr. Bagia, who had terrible credit. Neither Stephen nor Richard obtained a waiver to that conflict of interest. And the creditor did suffer a substantial loss and suffered harm. And that is the difference, it seems to me, in dispositions that have come out of this court and also out of the single justice sessions, where attorneys who have an obvious conflict of interest and don't receive a waiver, if there's been harm to a client, then suspension is considered warranted.
And he suffered harm because you say his interest could have been better protected in the transaction.
Yes, and there were specific findings about that, and that even after the transaction closed, Your Honor, Stephen continued to give advice to Mr. Boyer for the next 3 years, and during that period of time, a Department of Revenue lien was put on the first condo, which had to be removed. And at that time, Mr. Boyer asked Stephen to take steps to protect him from other creditors that might put liens on the last condo. And Stephen agreed to do it and didn't do it. And Gordine lien was placed upon that second condominium. And
I take it not only that he didn't do it, but he didn't tell him, oh, by the way, I'm not your lawyer.
not at that point, he didn't. And there's a specific finding about that he didn't tell him he was his lawyer until later in October of 1993. And when he told him that, Mr. Boyer did exactly what he said. He went to another lawyer, and he got other counsel on an unrelated matter. Now, I'd like to address some of the arguments made in Stephen Wainwright's brief. The first argument, which is that Stephen was not practicing law but was merely acting as a scrivener in this matter, is relatively new to the proceedings. It was raised at the single justice session. There's ample evidence in the record and the findings of the hearing committee that were upheld by the appeal panel of the board and ratified by the Board of Bar Overseers that Stephen was practicing, that right from the get-go he gave legal advice to Boyer and Baggia when they came to his office and said, here, we'd like to work out our debt situation. We'd like to, Baggia said, I want to give my property to Boyer, and Boyer will pay me the difference between what I owe and the value of the property. And Stephen advised him, no, you can't do that, based on some condominium law that he mentioned to them. And after that, Stephen spoke to Richard. Stephen executed a deal communicated the deal and executed the deal between the parties. He was a lawyer for the bank as well at the closing. He was representing everybody, it seemed, at that closing. It was only at the closing that Mr. Boyer learned that Richard was his lawyer. When he saw in the agreement, it laid out the amount of money that was being dispersed, money to the attorney for the bank. He didn't know that Stephen was the attorney for the bank. Didn't say his name. Money for the attorney for the contractor, that was him. And when he said, well, what's this, getting paid twice? And he said, no, Richard's your lawyer. That's when he learned that Richard was representing him at that time.
So he never hired Richard? So how was Richard his lawyer?
He paid Richard. He paid Richard. And Richard didn't consult with him. Richard didn't look out for his interest in structuring that deal or try to protect his interests. So there's ample evidence that Stephen Wainwright was acting as an attorney in these transactions, and that he continued to give legal advice even after the closing.
So it's a little bizarre. So Richard never even spoke to his client about this deal?
That's correct.
Never gave him any advice at all, never even met him concerning this deal?
That's correct, and there are specific credibility findings that the hearing committee made after hearing from all of the parties. The hearing committee did not credit Stephen Wainwright and did not credit Mr. Baggia when they testified that after Stephen met with Boyer and Baggia the first time, they went outside and they bumped into Stephen and they talked to him, and then they all came back in and had a meeting. The hearing committee specifically did not find that credible, and the hearing committee specifically did not find Baggia and Stephen's testimony that Mr. Boyer knew the whole time that Stephen was representing only Baggia.
Did Richard raise the issue in the hearings before the hearing committee and the board itself that he was not representing Boyer in that transaction?
Did Richard raise that?
Did he ever claim that?
No. He got paid for.
Yeah, I know he got paid for it, but did he ever claim that I didn't know the money came, that a check had been written out to me? I never knew that he was my client.
No, he didn't. He wasn't present at the closing, but he never claimed he didn't get the check, and he didn't. And he said it was his brilliant idea. In fact, those are his words. There's an exhibit in the record of his transcribed statement at the Office of Bar Counsel.
And I take it Richard then never claimed in the administrative hearings that he did this work at Stephen's request to come up with an idea, and that the work was done for Baggia.
No, Richard didn't. Richard didn't testify. The only testimony of Richard is part of the record, and it's his sworn statement that was given at the Office of Bar Counsel, where he acknowledged that he didn't, he didn't look out do anything more for Mr. Boyer other than come up with the idea.
But Richard acknowledged that
he was representing
he
Mr.
was in
Boyer.
an attorney-client relationship with Boyer for that transaction.
If they weren't his words, that's what he said. He said he represented Boyer in that transaction.
All right.
It was his idea.
Thank you. Thank you. Mr. Berman, you represent Stephen Wainwright?
That's correct, Your Honor, and only Stephen Wainwright. This is basically a case about a business deal, a very risky business deal that went sour. And I suggest to the court that if one should read pages 400 through 416 of the appendix, which involves the cross-examination of Elphish Boyer, one would find out a great deal that inconvenient truths that people would rather not talk about. We all know that this started when Mr. Boyer and Mr. Badger put a deal together among themselves, and the purpose of the deal was very obvious. From Mr. Badger's standpoint, it was to put money in his pocket. From Mr. Boyer's standpoint, it was to jump the long line of Mr. Badger's creditors and get paid himself.
Was that deal consummated as Boyer and Badgia had originally conceived?
Not, largely, but not entirely, Your Honor.
And how,
It wasn't entirely consummated as they had conceived it, because when they went to see Mr. Stephen Wainwright, and by the way, Mr. Badger testifies, Mr. Boyer testifies in the record that he assumed that Stephen was Mr. Badger's lawyer. When he goes to see Stephen Wainwright says, no, you can't do it that way. You just can't do that. You cannot take the condominium out of a trust with unbuilt buildings on it and convey it. And so ultimately, Mr. Richard Wainwright says, well, I'll tell you a way you can do it. And they do it that way.
at greater risk to Boyer?
At greater risk to Boyer, at both greater and lesser risk. The greater risk is, of course, that something will go wrong in terms of an attachment being placed against Badger, which is what happened. But the lesser risk is that if Badger goes into bankruptcy, which he ultimately did, as a matter of fact, this isn't going to be so. The trustee isn't going to come back and say, wait a minute, that's a preference, and you've got to give this money back. So there's a trade-off of risks. When I want to answer a question that Justice Cordy put to Ms. Robb. He asked why he waited to file the complaint. Well, I'll tell you exactly why Mr. Boyer filed this complaint. You'll find it in the record at page 408. He filed this complaint because he wanted to get his money back. He wanted to get back the money that he had lost on this deal. And he says so when he's cross-examined by Mr. Mathers, Richard Wainwright's attorney. And look, this was a deal with risk. Page 411 of the transcript. Mr. Boyer had no prior dealings with condominiums. Page 401 of the transcript. This was his last and only chance to get his money back from Mr. Badger. He had no builder's license. He had never built anything before except his own house. And he also testifies at age 416, I would have, if I couldn't get this money back this way, I would have eaten the loss. Those are his exact words. I would have eaten the loss. There was no sense trying to sue Mr. Badger.
The difficulty of getting back the money or the risk involved in the transaction has no impact on whether there is a conflict of interest. If anything, the increased risk of the transaction makes it even more important that one have knowledge advice of independent counsel.
Justice Sussman, let me reply to that, Your Honor. If these people had simply drafted a deed, if one of them had said, we don't need any lawyer at all, we don't need Stephen Wainwright, we don't need anyone else. Here, I'm going to deed you whatever, Blackacre. I'm going to deed you these 2 units. You give me $45,000 or $35,000, and we both agree this is worth $80,000. That risk would still have been there. The risk that when Mr. Boyer went to develop the condominiums, he would have problems and he wouldn't make money on this because he was inexperienced in what he was doing.
That is not how we measure whether there is a conflict. There is a conflict when interests are adverse. However many or few options each side has to extricate itself from the underlying problem, there is a conflict of interest when their interests are adverse. You don't have some exception for risky or problematic deals.
I'm not suggesting, Your Honor, I'm suggesting that we don't have a conflict when somebody asks a lawyer to simply memorialize a deal that they have already made.
But they didn't just memorialize the deal. They told him, Stephen told him, the deal you propose can't be done. And then got involved in arranging an alternate deal. Surely that's the giving of legal services?
You know, it is, and yet
It's not just Scrivener.
it's not, but suppose, Your Honor, that they did a deed and they asked Stephen to look it over and he said, you can't do this deed. The reason is you don't have no notarization on it. There's no verification. The deed could never be recorded. I suppose you would say at that point, yes, Stephen is practicing law. He's telling them something. But I just can't imagine how a lawyer would refrain from saying something like that when he's asked to review a deed. I agree with you that, yes, when they went to Stephen Wainwright, had he just said, I'll do exactly what you asked me to do and nothing more, this would on one hand be a easier case, and yet it would also be a more difficult case because I can't imagine any lawyer doing that. I can't imagine any lawyer who believes that you're doing something in a way you can't do it, just keeping quiet and saying, well, I'm only the scrivener, so I'll just do whatever you tell me to do. I am going to also suggest that any loss that was suffered by Mr. Boyer was really suffered. It wasn't the consequence of the conflict of interest. It was the consequence of his going into a field about which he knew nothing. That's why he suffered a loss. And I would, in terms of the interests, in terms of whether Mr. Wainwright told Mr. Boyer that he was not his lawyer and could not represent him in any conflict with Mr. Badger, there seems to be something afoot which says this didn't happen until October of 2003, but that simply is contradicted by the record. Mr. Johnson testifies, and this is the successor lawyer, Robert Johnson, he testifies that in in June of 2003, Mr. Wainwright is on the phone with him and says, Mr. Badger has a problem here, Mr. Boyer has a problem here, but I can't deal with it. I have a conflict of interest. Would you please take it? And I just can't believe that anybody rejects that testimony of Mr. Johnson. I suggest to you that the moment the conflict surfaces, where there's really an adverse interest, and they're not trying to do the same thing at all, they're trying to do two different things. Mr. Wainwright is very alert to this, and he does something, sends him to another lawyer. If there are no further questions for me, I thank you very much for listening, and I ask you not to suspend Stephen Wainwright from the practice of law. Thank you.
Thank you.
Mr. Wainwright, you have 3 minutes.
May it please, excuse me. May it please the court. My name is Richard Wainwright, and I'm here representing myself. It has long been established practice in our jurisprudence that when two people walk into your office and say, we've put a deal together, and we would like you to put it in legal terms for us, and we'd like you to draw up whatever papers are necessary to effectuate the deal which we have just come up with to solve our problems. Now, that's been part of our jurisprudence, but Bar Council and the Board of Bar Overseers rather would go with the old saw that a town may be too small to support a lawyer, but no town is so small that it can't support two lawyers. And this is what Bar Council says what somehow should have happened. We should have sent the two of them somewhere else and said, we can't draw up these papers for you because there's a theoretical conflict of interest somewhere. We don't know what it, but when two people, when you have a debtor and a creditor, we can't touch you. I'm sorry, go somewhere else, go to separate lawyers and let them handle your problems. I still, in my briefs and in everything I've said, I'm pretty proud of the fact that I came up with the only way to effectuate the deal which they had put together for themselves. And this loss, this supposed loss, is $8,000. It was based on an illegal attachment. When I came up with the idea, there was no possibility of anybody attacking it. The trust had no creditors, 0 creditors. There was no way anyone could legally go after this property. The attachment was illegal. The fact that Mr. Badger threw the summons in the rubbish and it eventually became a lien on the property improperly does not affect the fact that when I came up with the idea, it was the only way to effectuate. And there has my concern about the proceedings, as the unfairness of them. We're not allowed to present that. As a matter of fact, you start out. I've attacked the fairness of this whole thing. In the beginning, we're not allowed, the tribunal, you talk about the purpose of all of this, and the justice said the purpose is to have the public confidence in what's going on.
Mr. Wainwright, time goes by real fast, and yours has gone by. Do you want to say just a word or two in summation?
I just would like to say here, I pointed out that the complaint, Justice asked, why's the delay? The complaint was scriven, drafted, authored by a fugitive felon convicted of multiple counts of bribery, forgery, extortion, falsifying public documents. He's the one that created this complaint that this whole thing is based on. And the decision that's in front of you was drafted, authored, by a partner in a law firm that has been in a 3-year battle with my brother over ethics involving an estate. And that door out there, when you walk in, one of the words that strikes you as you walk through that door is impartiality. And I defy you to say that when Mr. McCrisky drew that document that's in front of you, that impartiality is not an issue.
Thank you. Are the other cases submitted?